Hello guys, I'm Prakash Lahiri, and today we'll be talking about law of contracts. So we'll be sharing on two main important topics that have been covered, and it is an important part of the Indian Contracts Act, that is the contract of indemnity and contract of guarantee. So before we start with the contract, we get into the details. I would suggest a few books that I have taken into consideration, then they can be really useful for the future references as well as for studying. Avatar Singh will be very much effective as to how you have to understand and learn it properly with the proper words, definition, as in case you're writing a written exam or judiciary you're appearing for, it will be really useful to understand the concepts. R.K. Dr. Bangya's book is also really useful as it comes in handy when it comes to the purpose of understanding and having a simplified version of what needs to be done. Then Pollock and Mullah will be really effective for the ones who are planning to appear for the future exams. Likewise, for judiciary and other purposes. So we would be suggesting that book as well. So now let's get started. So first, section 124 of the Indian Contracts Act defines contract of indemnity. It says that contract of indemnity is main purpose is to save the other person from loss caused. And how is that loss caused? The loss caused can be in two ways. First, by the conduct of the promiser himself, by the conduct of any other person who is responsible for causing the loss. That is known as the contract of indemnity. So the main purpose of contract of indemnity is to cover the losses. That's the main quotation that we look at, as well as it has a differentiated value as it said, that contracts has a different opinion. In Indian contracts, we have a different we compared to some in English laws, in which indemnity is one of them. Because contract of indemnity's main purpose is in English law is to cover the loss caused, and there it is by any act done at the request of the promiser. So any act that has been done by the promiser, that is the promise to cover for the losses, and then the purpose is that the person, the promisee does an act on behest of it, then the promiser is responsible to pay off the liability. Secondly, by any accident, event not dependent upon the conduct of any person. So in case there's a reservation for some amount of goods that has been stored near a place that is prone to the tsunamis or to the storms, and the storm has been caused. So if the storm has been caused, that might result in a hindrance. So it was a possibility that the covering of the losses to be has been not the loss that has been made is not actually done by the person himself by his choice, but it's actually a natural cause. So in that case, it has been referred here like this. Next, moving on, we have how is a promise of indemnity implemented, or how is it recognized? So promise of indemnity could be recognized in three ways, that is express or implied contract, contract of indemnity, as we know, relation of the parties, that is how is the relationship mentioned of the parties, if they're related as business client associate, or whatever the relation is, and what is by the statute, that is the mentioning of the law that has been established. So what are the good examples of indemnity? That's the best example to define, because indemnity sometimes is kind of confusing. So A and B are two joint promisers. They have to pay off a whole debt. So there is a debt of rupees 10,000 that has to be paid off, and A promises to pay half the amount, and B promises to pay the half the amount in the beginning. So both of them are joint shareholder, the joint promiser, pardon. So when they are called the joint debt promisers, so they'll be parting their sum that has been due. However, A provides the entire amount on behalf of B as well, and B then doesn't pay up, so he's used for half the amount, that is the amount that has to be paid up by B. So now it is the liability of the directors, that is the company, to compensate for the loss suffered by the person whose name has been appeared or has appeared as director without his consent, or has consent been withdrawn. That is, A is not supposed to pay the entire 10,000 amount, but just the 5,000. And now, since he's paying 10,000 in the entirety, it's the company's responsibility to pay off the 5,000 on behalf of B, since B has failed to do so. Now, the next is commencement and extent of liability. So this has been a controversial topic which has been clearly seen, and this was really put on with high emphasis. That is, during the era of the Law Commission, it was stated that the English law has a different circumstance in comparison to what is the circumstance that's perceiving and that is persisting over the country of England, because they had the different principles. So what the main point was that in English law, it was stated that no indemnity till the actual losses have been suffered. So if a person A has now asked for some amount of compensation, that is a minor loss, for the records to be carried here, the goods shifted, for example, from carrying, transportation, and now the problem is that there is a prediction that there might be certain losses that are going to be incurred. So if the person fails to prove that there has been any incurrence or there has been no incurring of any losses, then there will be no provision to provide indemnity. However, might the situation be that the person is in a position and it might hinder the view. So this was the question, as we said, that difficulty with the earlier position as it caused great hardship when the person was not in a position to meet expenses from his own pocket, as I mentioned. Now, in the equitable court principle, to the doctrine, the equitable court changed this rule, stating that it was no more necessary for the indemnity holder to be indemnified before being indemnified. What does this mean? That the person, if there has been no losses caused and there will be no pay up to it, but there is a possibility that that might happen, so then it is the responsibility of the person who has promised that he shall pay off the person who is apparently supposed to be suffering. And this was highly recognized, and due recognition was made with the Law Commission of India that observed that indemnity is a claim and not a mere reimbursement. So a landmark judgment that came up for this was in Gajanan Moreshwar Parelkar versus Moreshwar Madan Mantri. It was held likewise that section 124 and 125 are not exhaustive in case of law of indemnity, and the equitable principle would be applying to India as well. So before, equitable courts did not have the jurisdiction was confined to the British rule. It was just confined to them, not entirety was provided. So then the indemnified has incurred liability, and that liability is absolute, and is entitled to call upon the person who has to indemnify to save him from the losses by paying him off. So indemnity case, what it means that the person has promised to pay upon behalf of person and to prevent any losses incurring. So that is the main concept. So we have other two cases as well, Osman Jamal and Sons versus Gopal Purushottam, as well as SBI versus Mula Sakari Shakar Karkhana. They're two important cases. And now let's come to the rights of indemnity holder. So what are the rights of the indemnity holder when he's sued? So section 125 reads that the promisee in a contract of indemnity acting within the scope of its authority is entitled to recover the sum promised for all the damages that have been incurred, for some of the damages, that is the all costs, that is completely situational based on the interpretation of the person, as well as all the sums as the notice may be given accordingly. What are the limitations of contract of indemnity that we have to look at? Firstly, the indemnified cannot sue the debtor in his own name for the want of privative contract. So for the privative contract concept, as it goes on, there cannot be third party indulging, and the consequences are that the person who is taking cognizance of these facts is actually suffering from another criterion. The crisis is the fact that he cannot sue or cannot be sued, apparently. The next is that the creditor also cannot sue the promisor of the contract of indemnity. That is another concern. That is such often because the creditor, whosoever is the promisor, now cannot charge him or cannot sue him for the from contract of indemnity because he is not the party involved to it. So these are certain consequences. Now, what are the rights of the indemnifier? So this statement needs to be understood on the basis of the principle of natural equity, where one person has agreed to indemnify other, he will, on making the good, the indemnity will be entitled to succeed all the ways by means by which the person indemnified, pardon, indemnified might have protected himself against or reimbursed himself for the loss. What does it mean? Now, one person has agreed to indemnify another. So A has agreed to indemnify B in case of a crisis. He will, on making the good indemnity, he will be entitled to succeed. So the person B now has decided upon that he will take cause that since these goods have been indemnified, now he will find all the ways to make A pay him the money, pay him the money and recover all the losses. This is the basic concept. Now next is comes in the most important concept, is that is the contract of guarantee. You have to understand there is a slight difference between contract of guarantee and contract of indemnity. So we'll understand as we go on. Section 126 of the Indian Contracts Act defines guarantee, and it says that guarantee includes, that is, a performance of a promise which corresponds to a duty. That duty is basically a discharging of liability which is corresponding to a debt. And that debt, what does in corresponding case of a debt, it means that in case there is a default that has been made, because if the person makes default, only then the contract of guarantee can be made. Now, how can contract of guarantee occur? It can either be orally contracted or written. There has been no specification that can be in both ways. Now, the problem is that what are the parties that are involved? So there are three main parties that are involved in the contract of guarantee. That is the surety, the principal debtor, as well as the creditor. So who all are they? So principal debtor is the person who takes the loan or the money from the creditor, who gives out the money. And surety is the person, the third person, who makes sure that in case the principal debtor fails to pay the money, the creditor, that is the creditor, then the surety will pay the money on behalf of the principal debtor. Now, let us look at in a defined way. What are the essentials of a contract of guarantee? As we have mentioned already, there are three parties that are necessary. That is the principal debtor, surety, and the creditors. Next, the contract can be in written or oral form. Thirdly, there should be a principal debt. That is, there has to be a money indulged in it. So if there has been no money involved that is going to be leading to the borrowing a certain fact, then there is the possibility that the person can take for the cognizance of suing or getting sued. Those are the certain circumstances that have to be looked at, and we will look at it. And for the contract of guarantee to come into existence, the most important aspect is the fact that there is a need to have a default, a principal default. Now, what do we mean by principal default? That is, the principal debtor fails to pay up the money. So the contract of guarantee has been defined as such that the person who is responsible for the payment will only be liable to pay if the person, that is the principal debtor, fails to do so. And that is so. And if he, that is the principal debtor, doesn't fail to pay up the money, then there is no need to pay the money in future. So there will be no necessity. The main aim of contract of guarantee was to ensure that there is no losses incurred, not to cause excessive gains to the creditor. So next is that the consent of the surety must have not been obtained by misrepresentation or concealment. Then the contract fails immediately, as we know the nature of the contract if it is obtained by fraud or coercion. Next is the consideration. Now, what is a consideration for guarantee? So for a contract of guarantee to exist, we need a consideration. However, the consideration might be a bit different from the consideration that has been defined in the general contract. To a certain extent, not exactly very different, but to a certain extent. So section 127 speaks for anything done or promise made for the benefit of a principal debtor may be sufficient consideration to the surety giving guarantee. What does it mean? That the person, for the benefit, for the benefit of the principal debtor, does anything, that is anything done or makes a promise that might be a sufficient consideration to surety for the guarantee. So supposedly A does anything, that is he delivers goods, that will be shown in the example, that B requests A to deliver and sell him goods on credit. A agrees to do so provided C will guarantee the payment in consideration of A's promise to deliver the goods. This is sufficient for C's promise. Now, how is it related to the section 127? Here it goes. B requests A to deliver and sell him goods on credit. So what is the profit he is getting here? The profit that he is achieving here is the fact that he is going to receive the goods. That is the benefit he's attaining. Now, what is the question that has been asked? That to sell him goods on credit. Now, A, as the creditor, agrees to do so provided that C, who will be the surety, and he will guarantee the payment in consideration of A's promise to deliver the goods. That is, if A delivers the goods, then C will make sure that he pays the money. This is the consideration. What is the benefit? If it is for the benefit of the person, that is, if it's benefit for the B, then C has sufficient consideration, that is the delivery of the goods will be considered to be of use. Next is section 129, which speaks of continuing guarantee. Now, question is, what do we mean by continuing guarantee? A guarantee which extends to a series of transactions are called a continuing guarantee. Now, what is a guarantee has been completed in one phase. Now, what has happened is the fact that the person intends to continue. The person continues to extend the guarantee for a longer period of time than the contract that has been due. In that case, it will be considered as an extended guaranteed or continuing guarantee. Now, what are the examples? That A in consideration B, that B will employ C in collection of rent of B's zamindari, promises B to be responsible to the amount of rupees 5,000 for due collection that has to be given as money and the further collections and payment of those rents. So what is the consideration here is the fact that collection of money. And who is the surety here? That B is surety for collecting B's money. A will be said that B will be taking responsibility to do so. So these are the small important aspects that have to be looked at. And the most important, I think the landmark case that took place was the Eastern Bank Limited versus Parts Services of India. That's a landmark case. I suggest everyone to have a go through the case with the citations and the details that have been mentioned. Next is the most important topic that we are going to discuss, that is the differences between the guarantee and indemnity. So under contract of guarantee, there are 3 parties involved, whereas in the contract of indemnity, there are only 2 parties. Now, the contract of indemnity consists of only one contract, that is between the indemnifier and the person who is to be paid, the creditor, in the indemnity, whereas there are 3 contracts in the contract of guarantee, that is between the surety and the creditor, surety and the principal debtor, and principal debtor and the creditor. There are 3 contracts. Now, the object of the contract of guarantee is to secure the interest of the creditor. The contract of indemnity is made to protect the promise against certain loss. Now, the point that comes into question, that how is it different? Then in the contract of guarantee, the liability of the surety is only a secondary one. That is only when the principal debtor fails or ceases to pay the money, only then the guarantor or the surety has to come in. The liability of indemnifier is the primary one in the contract of indemnity. It arises when the contemplated situation is there. Whenever the situation takes place, at that point it is arising. Next is the surety can recover the compensated amount from the principal debtor, whereas in case of indemnity, the indemnifier cannot recover from amount once paid. Now, what is the nature of contract of guarantee? The contract of guarantee is a collateral or is conditional contract, because if it is taking place only then, if it is happening only then the contract will come into force, otherwise not. Contract of guarantee is an auxiliary, or is it a addition to an antecedent obligation, that is antecedent obligation that any obligation that has taken place. And now what are the grounds? So there are two classes of guarantee: a situation where a promise which becomes effective if the debtor fails to perform his obligation, and the promise that the debtor will perform his obligation. Guarantee in the latter cases are effectively unconditional. Now, what does it mean? Here, the question is that in the first case, if the debtor fails to pay the amount, then the surety will pay the money. Second case, a promisor promised that the debtor will perform his obligation. That is, the debtor has to pay up the money, and then there will be no need. So that is what I said, that the guaranteed latter case are effectively unconditional, because the person is already paying off the money. Next is the contract of guarantee is an agreement under which the promisor undertakes an obligation which replaces or extinguishes the principal debtor's liability, whether by novation or otherwise, is not a guarantee. This is what it means by when we say a contract of guarantee is not uberi fidei, but a contract of strictisma juris. Next, as we move on, guys. Here are certain important features things that have to be noted down carefully as we go on. That is, in the first place, that surety against a minor contract as the principal debtor, because a minor is generally not allowed to enter into a contract. Secondly, the fact is that the liability should be legal enforceable. Whatever liability is there, it cannot be said that the person who's entering into drug or illegal carteling or activities as such, then the person cannot seek for any enforceability. Thirdly, surety's liability is equivalent of that of a principal. That is, the principal debtor amount of money that has been owed by the principal debtor will be equivalent to the money that is paid out by the surety. The liability of subject to condition, if provided, that means that if there is a condition that has been provided that limits the monetary power or the fiscal power of the surety, then if the power limited, then the liability cannot be extended to the complete situation. Next is the principal debtor may be a party to the contract by implication. We all can understand this, that a principal debtor is a part of the contract if it has been mentioned so properly. Next we have for the filing of suit. For the filing of suit enforcing entitlement, it is not necessary for the creditor to exhaust suit against principal debtor. So this is mainly similar to the grounds that has been mentioned. The liability to be proved in the same manner as the principal debtor. Yes, the liability of the creditor has to be proved in a similar manner as that of the principal debtor. The surety and the principal debtor have the same grounds. Next is contract of guarantee without consideration is void in nature. Liability of contract under contract of guarantee. Section 128 speaks for surety's liabilities. The liability of the surety is coextensive with that of principal debtor unless it is otherwise provided by the contract. That is, whatever the conditions have been persisting, if they don't specify, then it is coextensive to that of what the principal debtor owes. And this was decided in a landmark, and this was implicated as well as it was defined properly in the case of Narayan Singh versus Chattar Singh in 1973. Next, as we move on, Section 132 speaks for liability of two persons is primarily liable, not affected by the arrangement between them. One shall be surety in case of the other's default. So if there has been no mentioning about as to what needs to be done, then one person will be taken to the cognizance of being another's surety. Next, Section 144 speaks for that guarantee on the contract that creditor shall not act until if the pure surety joins. That is, until the surety joins in, the creditor shall not provide for the goods or shall not enter into contract. So if there is a situation where there are co-surety, that is the surety until unless it joins, till then the creditor has the power to not enter into contract with the principal debtor. Next, whatever the powers of the co-sureties are, so co-sureties are liable and they have to contribute similarly, and whatever the rest of the due money that has to be held by them. Next, that question that arises very specifically is liabilities of the sureties are duty bound in different sums. What does it mean? That any liability that has been owned up like that has to be dealt with proper case and in a proper manner. Next, we look at that is the liability of a void or avoidable contract, then there shall exist no liability surety against a minor's issue. The second is the discharge of principal debtor operational law does not discharge surety. That is, the person who becomes bankrupt or becomes insolvent, then the surety is not discharged of any liability. He still has to pay off the liability that has been owned up. Statutory reduction extinguishment of liability generally does not take place, but if it is needed, then it can be done according to the terms and conditions if they are needed to be changed in the contract. The next issue is that this filing of suit, an issue or a decree can definitely take place, and effect of the acknowledgement by the principal debtor does not bind the surety unless specifically empowered. This is a very specified issue. There has been no such comment that has to be required to be made. And the document of release in favor of principal debtor without rights against the surety, that also cannot take place. Now, revocation of a contract of guarantee or a revocation of a contract of continuing guarantee. So a continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditor. Then it can be revoked by giving notice to the guarantor so that the guarantor can avoid future liabilities. Where a continuing relationship is constituted on the faith of guarantee, it cannot be revoked during the continuance of the relationship. However, material change provided that there is certain misconduct or there's such activity that can infer and that completely dissolves the main purpose of the contract, then it can be put to the issue. Then it has to be done with the prescribed mode of revocation that has been provided. And the change in the status of creditor would terminate the guarantee unless agreed otherwise. Revocation of continuing agreement by surety is death. Now, the death of the surety operates in the absence of any contract, to the contrary, as a revocation of the continuing guarantee, so far as regards the future transaction. The death of the surety operates in the absence of any contract, to the contrary, as a revocation of the continuing guarantee, so far as regards in future transaction. So, this was an important case, to Sitaram Gupta versus PNB, where it was held that in the absence of any contract in contrary and joint and several liability, the surety can be continuing guarantee can be revoked contract. And it was held that the appellant, having entered into agreement of guarantee with the respondent bank, revoked by a letter written to the manager of the bank before the loan was in fact advanced by it. it was held that it was not open to appellant to revoke the guarantee. The apex court held that since he had waived off his right under Section 130, such revocation is not maintainable. Now, discharge of surety. Section 133 says that discharge of surety by variance of terms of contract without the and this has to be a rule of strict interpretation. The variance should be substantial, and it should also not have the consent. And it has to be noted that the rule of contra preferentum has to be taken, which was held in case of Bonner versus McDonald, which held that the case the defendant was a surety for the conduct of a bank manager. Subsequent to this agreement, the bank enhanced the manager's salary, and the manager agreed to be liable for the 1/4 of the losses on discounts allowed by him. This arrangement had been made without the knowledge of the surety. The surety stood discharged from such liability. The note has to be made that the variance which has been made in the contract is without the consent, and then it can be discharged immediately. Next way is that release of principal debtor by complete novation or otherwise terminates the guarantee. Acceptance of second surety by the creditor, consent or decree, or there has been a compromise made, and this was held in the landmark case of Aniruddham versus Thomco Bank. Section 134 speaks for discharge of surety by release or discharge of principal. That is, a surety is discharged if the creditor, without his consent, unconditionally releases the principal debtor. So then if the principal debtor has been removed, then there is no role for the surety to take action. And this was also held in important note on Insurance versus Security Finance Private Limited. The third is Section 135 speaks for contract between principal debtor and the creditor to give time to agreement not to sue, extracts would discharge the surety. What it means that the contract with principal debtor and creditor to give time to or agreement not to sue would discharge surety. So if there is time given upon negotiation, then the surety does not have to be in there. Then at that point, it has been discharged. Section 139 speaks for discharge of surety by creditors, act or omission impairing surety's eventual remedy. Now, Section 139 includes that one does act consistent with the rights of the surety, omits to do any act which is his duty to the surety requires him to do, and as a result, the surety's eventual remedy against the principal debtors is thereby impaired. Which means that Section 139 is residuary in nature, which ensures that no contract arrangement is made. So there are certain places where cases where under Section 139 where it can be held, that firstly where the creditor consented to the release of attachment over the properties, where creditor failed to convey property in purchase, the price of which was guaranteed by the guarantor, sale of mortgaged property in favor of the creditor without telling any occasion for the same, loss of pledged goods, failure of creditor to bring on the record of LRs of the dead principal debtors resulting into abatement of the proceedings against him, security not returned in the same condition as given to the creditor. Surety is not discharged in the Section 136 is when agreement with the third party person gives time to the principal debtor so as to make sure that the surety pays the money. Section 137 says creditor's forbearance to sue does not discharge duty of the surety. Section 136 release of one co-surety does not discharge others. That means that one has been released, the other does not automatically get discharged, but it has to be discharged in accordance to the contract or the ways. Section 140 of the Indian Contracts Act speaks for the rights of the surety. That is, the surety becomes invested with all the rights which the creditor had against the principal debtor. That is, entitlement for part payment based on the principle of equity. In counter guarantee for reimbursement, the rights are transferred to the counter guarantor, the person who guarantees the guarantor. Next is the priority in case of liquidation winding up. The rights before demand of payment once the liability accrues. Injunction even before the payment. Section 141 says that surety's right to benefit of creditor's security. Surety is entitled to all the security creditor had at the time of entering into contract of surety, irrespective of the knowledge of the same. Any impairment in the same would discharge the surety. Section 145 talks about implied promises to indemnify surety.
That is firstly rightfully paid, that is includes property, assignment of rights. Entitlement runs till full indemnification is done, including recovery towards payment. Next is recovery of cost. Includes cases where surety has defended the debtor under his authority for his benefit or under circumstances which were unavoidable. Circumstances in which disclosure is necessary to be made to the surety. Where the surety has asked specific question to the creditor, where the bank misleads the surety by volunteering only part of the truth, where the surety makes a statement in the creditor's presence that demonstrates that he entirely misunderstood the principal debtor's position, where there is a situation, anything that might not naturally be expected to take place between the principal debtor and the creditor. And lastly, the cases that have to be looked upon. These are not exactly which is compulsory, but it would be great if you could go through them, and it would be great if you have SCC. So the cases are GAIL, Gas Authority of India Limited versus Office of Official Liquidator, Mumbai. Next is Syndicate Bank versus Pamidi Somaiya. Next is MS Anirudhan versus the Thomcos Bank Limited. Ram Narayan versus Lieutenant Colonel Hari Singh and others. State of Bank of India and others versus Mullah Sahakari Shakkar Karkhana. Syndicate Bank versus Channa Virappa. And finally, United Bank of India versus Satyavati Tandon, 2010. So thank you guys. And I would really appreciate, and please do keep sharing. Thank you.